This is part 7 of the series on reviewing a client's estate plan. As a refresher, this is a series that's designed for attorneys, wealth advisors, and tax advisors who deal with estate planning issues as part of their practice. But this is not intended to be a self-help resource if you're a consumer of legal information. So I want to remind you that this video cannot be relied upon to assess the health of your own estate plan. I'm Griffin Bridgers, and this is Reviewing a Client's Estate Plan, Part 7. Today we're going to dive into lifetime medical decisions. Now before I jump into the presentation, I have to give the usual caveats that 1. This presentation is not intended to substitute for legal or tax advice and is provided for educational purposes only. And 2. This video cannot be relied upon to assess the health of your own estate plan. Without further ado, let's go ahead and get started. So we've covered a lot of ground so far. We've covered 6 parts which look to titling, beneficiary designations, a roadmap of a lot of the documents on a basic, intermediate, and advanced level, an intro to wills, looking at class gifts and asset classes, and then finally looking at the various fiduciaries that can be named within a will. So today we're going to start diving into less the documents effective at death and more the documents that are effective during life. And specifically, we're going to look at the documents that cover lifetime medical decisions and how your wishes can be carried out. So the target results of today will be 1, determining the types of documents that you use for medical decisions, and 2, identifying fiduciaries and maybe some other observations within those documents. Now, once again, why am I doing this series? Well, I want to note that non-attorneys are already out there reviewing estate plans and sometimes charging for it. So this is really just a resource to better educate those who want to review estate plans and protect clients in this area. So, medical decisions during life. If you are in the hospital and cannot make a medical decision, typically you need somebody to make those decisions for you. So the question is, who is that person, and will they have any influence over learned medical staff? So, many documents in the estate plan take effect during life, including those for medical decisions. Now, typically, the lowest hanging fruit where you start is with a medical power of attorney. Now, formally, this is known as a durable power of attorney for healthcare. Sometimes it is just a medical power of attorney or healthcare proxy. This durable term is important, and we'll talk about that in a few minutes. But the medical power of attorney is not enough in and of itself. Typically, this has to be supplemented by a living will, which is also known as an advance directive for medical or surgical treatment, and a Hipaa authorization and release. Now, these can be 3 standalone documents, or they could be 1 document packaged together, and maybe sometimes you see the Hipaa authorization and release just included in the medical power of attorney with a separate living will, or vice versa. But either way, there's no right or wrong way to do this. The state custom, depending on which state you're in, may vary. But you have to have at least a document that has these 3 components, starting with the medical durable power of attorney, whose primary function is to name an agent or proxy who can make decisions, medical decisions on behalf of the person executing the medical durable power of attorney, who is known as the principal in most cases. So you have a principal creating a medical durable power of attorney, and then an agent or proxy who's charged with making medical decisions on behalf of the principal. So the biggest review point is just checking who that agent or who the plan of succession would be for that agent, and making sure that the client is still comfortable with that plan of succession. Now, I want to remind you that oftentimes this isn't something where you can just cherry pick people. Agents are charged with making a potentially weighty emotional decision. So because of that, you should always be making sure that the agents are suitable for the weight of the medical decision which may be involved. And you can take some of that weight off them, as we'll mention in a second. But for the time being, another big thing to check is what's the triggering point for the agent's authority to kick in. Oftentimes, with the medical power of attorney, you'll see either an informed consent standard or an incapacity standard. So, if incapacity is the trigger for the agent's authority kicking in, then you have to figure out that threshold for incapacity. Who determines it? Can it be determined by the agent themselves, or do you have to go to an outside party, like one or two physicians, or the court, or maybe just the agent's discretion? Would any of those suffice? And how difficult might it be to get that given the principal's situation? I also want to mention too that instead of incapacity, really the intent of the power of attorney is that it would kick in, or the agent's authority would kick in, when there's just a simple inability to provide informed consent to a medical procedure. So both of those are nuances you can look for within the medical power of attorney. Now, in terms of what the powers are, you'll typically see those spelled out, and we're not going to dive into that, but there's subtle nuances that are unique to the principal. And typically, that's not stated in the document. What you would typically see is that the agent is charged with acting in the principal's best interest based on what the agent knows or believes that the principal would want. And obviously, to make those decisions, the agent would need a Hipaa waiver, and we're going to talk about that in a few minutes, to actually be able to communicate with medical authorities. Now, the biggest thing is this second to last point, the agent's discretion to make medical decisions. That's where the weight of the emotional medical decisions come in. And this can be supplemented then, or even replaced, by a living will. This can relax this discretion or take it away from the agent and form it into a document which is designed to address end-of-life decisions. This cuts the agent out because the living will is a direct communication from the principal who's creating it to the healthcare provider as to how long life-sustaining procedures should be continued if treating medical personnel determine that there is no chance for survival. Now, I want to note, a lot of times people confuse this with a do not resuscitate order or a DNR, and a lot of times the DNR is a form on file with the hospital itself using the hospital's own form. Now, it could be included in the living will itself, but the problem is, obviously, the living will typically isn't carried around on somebody's person and isn't available to a medical personnel. And medical personnel are charged with risk of grave liability to honor a DNR no matter what. So, if you have this in the living will, what you have to do is also come up with a better plan to communicate this desire not to resuscitate you to medical personnel. Now, that's a whole rabbit hole we could dive down and spend a lot of time on, but I just want to address that as a surface observation for part of the review of this, beyond just how long life-sustaining procedures should be continued. You might also want to check for the level of discretion for the agent. Does the agent have the power to override the wishes set forth in the living will, or are those wishes set in stone? And are those designated wishes still valid if the living will was executed a while ago and maybe health circumstances have changed? You might also want to look and see if there is an instruction for organ and tissue donation within the living will or the medical durable power of attorney itself, and make sure that those are up to date as well and still within the client's wishes. Now, when you look at a medical durable power of attorney versus a living will, they're independent documents, but there is a little bit of overlap depending on the level of discretion that the agent has, either to override decisions in the living will or to have to respect them absolutely. And why might you give an agent discretion? Well, maybe there's a Hail Mary type of decision out there where maybe somebody's undergoing cancer treatment and under conventional medical guidance there is no chance of survival, but maybe they qualify for a trial or something like that. And in that case, you have to consider, do you give your agent the authority to make that tough call if there's that Hail Mary type of solution? This is a carryover from the last part of this series, part 6, where we looked at medical decisions. Now, decisions during life typically are charged to the agent under the medical durable power of attorney, who could be the guardian as well, as we'll look at in a second. You then flow that to the living will, where you have the option for fiduciary discretion. And then after death, that kicks more over into funeral instructions, which is a separate document and a separate discussion. Now, there's some additional observations to make with respect to the agent. One, is the agent nominated as a guardian in case a court-ordered or court-supervised guardianship is required under state law? If so, it may be a good idea to have control over that process by nominating the agent as guardian. And the court doesn't necessarily have to follow the nomination, but it can give it significant weight depending on the state you're in. Another question is whether the agent can make medical-related decisions, not necessarily medical treatment, but more things like assisted living decisions. You may want to spell out things like that, or even the ability to pursue a lawsuit if there's malpractice in a course of medical treatment received. And also, you may want to check if you have two agents named maybe to act together or named simultaneously, do they have to unanimously consent, or can they have independent decision-making authority? Unanimous consent can be difficult to obtain, especially when agents live in different parts of the country and there is the need for an urgent medical decision. And in that case, independent decision-making authority may be granted where you want agents to share the authority and maybe want an option without formal succession. And it goes without saying, for any power of attorney, if you're an attorney drafting it, it should always be durable. What that means is it remains effective if the principal becomes disabled or incapacitated. And if you're reviewing a medical power of attorney, don't assume the obvious. Make sure you check that it's durable. Finally, we have the Hipaa authorization and release, which could be a standalone document or even part of the medical power of attorney. But either way, you want to make sure this document is somewhere wrapped into the entire package of medical decision documents, because without this, your agent may not be able to discuss your medical records or your personal health information with treating personnel. They're not obligated or to disclose that or even discuss that type of thing, even if you have a medical power of attorney, because HIPAA protects your personal health information. Medical providers are subject to significant liability if they breach HIPAA. And obviously, you can't consent to disclosure of personal health information to your agent if you're unconscious. So make sure that you have this document. Otherwise, pun intended, your agent could be rendered incapacitated in their role as agent. So that covers medical decisions. What else is coming up in this series? Well, we're now going to dive into more of the hard stuff. Things like AB trust structures within a will or revocable trust. Might also look at trustees of revocable trust and how you can bifurcate that role. You might dive into agents and the nuances of agent authority under general powers of attorney, and more. Now, I want to remind you that this process of reviewing a plan, depending on how deep or narrow you go, is an infinite process which could generate infinite videos for me, but I don't want to do infinite videos. I probably won't continue this series past about 12 videos or so. So because of the finite nature of this series and the finite nature of my ability to educate you on this process, what I want to offer up as my value proposition is for the more advanced stuff beyond the videos, I'm happy to be a resource. So please help out if you need an estate plan review or need assistance with one, especially in a non-legal function, because this is not an attorney solicitation. So while I welcome you to send questions or topic suggestions to me at griffin.bridgers@gmail.com, I want to remind you that I cannot give tax or legal advice in response to your questions, and that this is not an attorney solicitation. And I remind you again that this video cannot be relied upon to assess the health of your own estate plan. But thank you again for listening to this part 7 of the series on reviewing a client's estate plan, and I look forward to seeing you in my future content.